My name's James McHugh and I'm here to talk to you briefly about statutory demands and how to avoid some of the common pitfalls once they are issued. They're a commonly used tool in commercial litigation, particularly when you're dealing with debt recovery. Popular in that they're cheap to issue, they're relatively straightforward and not covered by the CPR generally, and the consequences of them mean that usually people don't ignore them when they get sent over to a debtor. However, unfortunately, if you get it wrong, the cost consequences in particular and the potential for satellite litigation is significant. And so the purpose of this talk is to try and go through some of the common areas that I've come across in practice in which practitioners have gone wrong and fallen into error when getting their statutory demands out. In particular, this talk is going to focus on three areas: service, whether or not a debt is disputed, and offers to compound or secure a debt that's been demanded. Process comes slightly after the demand and usually at the point of a bankruptcy petition, but it's relevant anyway because the law's relatively complicated. People often get themselves in a bit of a mess in relation to it. Dealing first with service. Probably the first thing that debtors look to challenge when a statutory demand has been issued is whether or not it has been properly served. Reason for that is obvious. If it's not been properly served, normally it can't be relied upon to form either a bankruptcy or a winding up petition, apart from in limited circumstances. The reason I mention service as an issue, I'll give you an anecdote of where it can go wrong. I was once dealing with what was going to be a bankruptcy petition in relation to two directors who had provided a personal guarantee on a company. My instructing solicitor had done everything right, issued the stat demand properly, drafted it properly, and their case was fairly solid. They passed it on to a professional process server and given them instructions for what to do. Both of the directors were in the same building together. Personal service was required. The process server handed both of the demands to one of the directors and then claimed that he'd effected personal service on both of them, thus torpedoing our case against one of the directors who had in fact not been served and claimed that his fellow director never passed it on even though they were in the same building. So even if you do everything right, it can still go wrong. Some of the stuff I'm going to talk about is relatively basic. Make no apology for that. It tends to be the basic points where we end up tripping up and getting in trouble. Starting point in relation to service. CPR 6, which normally applies to service of documents, does not apply in relation to statutory demands. That's as per Schedule 4 of the Insolvency Rules of 2016. The rules differ, obviously, if you are serving on an individual or a company, and if you're serving on a company, the requirements differ depending on whether the company is registered or unregistered. Dealing with serving on an individual. Rules for service are in 10.2 of the Insolvency Rules. What a creditor has to do is all that is reasonable to bring the statutory demands to the debtor's attention and, if practicable in the particular circumstances, serve the demand personally. That's where in the story I've just told, we came unstuck in the demand that was handed to one rather than both directors. If you're serving on a registered company, that's dealt with in the Insolvency Act, section 1231A. There has to be a written demand in the prescribed form and it has to be left at the company's registered office. Theoretically, that can be done by posting the demand. Normally, best practice is get it served personally so there can be no dispute. I've set out in the handout there a 1992 decision in which it was said service can be validly effected by post to a company's registered office, but that was a case where there was no dispute that firstly it had been sent by what was then registered post and what would now be guaranteed delivery, where you have a receipt of delivery, and there was no dispute from the recipient that the demand had been received. If there is going to be any dispute, and quite often in cases like this, I suspect those of you practicing in this area will know, one of the first things that a debtor will say is, I never got this document, I've never seen it before. If there's going to be any dispute at all about whether the document has been served or not, get it served personally, and so you can get the person serving it to provide a witness statement saying that it has been served. Dealing with an unregistered company, that's governed by section 2221A of the Insolvency Act. This case, unregistered company has to be left at the principal place of business, delivered to the secretary or some other director, manager or principal officer of the company, or otherwise served in a manner that the court might approve or direct. Obviously, the trickier thing is there's no registered office for an unregistered company. Normally, you will be able to identify what the principal place of business is. Again, it is possible to effect service by post, provided that there's not going to be any dispute about receipt. The golden rule for stuff like this is debtors love to say, I've never seen this document before. It's usually how they get themselves into that mess in the first place. And so make sure you've got somebody handing it over who can provide a witness statement saying this has been received. Unlike bankruptcy petitions, unlike in individual insolvency and bankruptcy, for company insolvency, stat demands have to be served as a hard paper copy. You cannot serve them electronically. There is a specific carve-out in section 436B of the Insolvency Act, which excludes the service of statutory demands for companies from the meaning of in writing from being electronic. For every other measure, or for a number of other measures, in writing under section 436B counts as electronically or by email, not for a company stat demand. That has to be hard paper copy that you serve with. I've already touched on this, but in terms of proof of service, presentation of a bankruptcy petition requires proof that a stat demand was served. Whilst there's no longer a set form for the certificate of service, there used to be, it was scrapped with the 2016 insolvency rules, there must be some sort of certificate that contains a statement of truth prepared and signed by the person who served the demand. Where it's not been served personally, the certificate has to set out the steps taken to serve the demand, and crucially, this is very important, the date by which the debtor is likely to have become aware of the notice. In practical terms, if you were doing this, you would not only produce a certificate, you would produce a witness statement, either from the file handler or preferably from the person who carried out service, in addition, setting out exactly what steps they took to serve, when they did it, how they did it, and whether or not service was affected. For company insolvency, for a winding up petition, you don't formally require proof that a stat demand was served in accordance with the rules, but as I've set out in the handout, it will be a very, very brave petitioner indeed who presented a winding up petition without having proof that they'd served a stat demand. I suspect in practice it would be foolhardy rather than brave. What I would recommend is that you take a similar approach to that I've set out for individual insolvency above, certificate of service and a witness statement from the person who served, setting out what steps they took. I've set out in the handout some practical tips. A number of them I've already touched on, so I won't repeat them here, particularly because there's some time constraints and we're running a little bit behind. But they can be summarised as making sure if you use a process server, the process server knows what they're doing. I had another case where a process server who was required to serve personally got bored of waiting and posted it through the letterbox and then said, oh no, we did everything that we had to. We know they were in, and obviously it was no good. We were snookered in relation to that application. Witness evidence is key, and particularly witness evidence is key if you're going to try and argue that it wasn't reasonably practicable to serve personally in personal insolvency. I would go so far as to say it's absolutely crucial. The judge hearing the application or hearing the petition will expect you to set out why you weren't able to serve personally, what steps you took to be able to serve personally, and why it was appropriate for you to serve in the manner that you did. Moving on then to disputed debts. Another extremely common approach taken by debtors is to try and challenge the debt that you've issued the demand for. The reason why it's so important to get this right is, some of you may know, there's case law that effectively says if you inappropriately use the stat demand process for a debt that you know to be disputed or is likely to be disputed, not only can your petition, either a winder or a bankruptcy, be dismissed, but it's likely the case that you'll be made an award of indemnity costs against you, because the courts don't like you to short-circuit the dispute resolution process by issuing a stat demand. The escape clause, if you like, for a disputed debt applies to both personal and company insolvency. It's set out in the Insolvency Act for bankruptcies, and a valid reason for non-payment of debt. Dispute in this case means that there's no neglect for the purposes of a winding up petition under section 123 of the Insolvency Act. The key battleground normally in relation to these cases is whether or not the debt is disputed on grounds that appear to be substantial. Much like you have heard in Antoine's talk earlier, normally you know it when you see it if there is if there are grounds that are substantial to a disputed debt. Most of the guidance in the insolvency sphere now in relation to whether disputed debts are on substantial grounds or not are taken from the CPR guidance in relation to summary judgment applications. I've set out there the case of Easy Air Limited and Opal Telecom in the handout, which is a very good summary on the approach taken in relation to real prospect of success. The court will usually apply a similar approach if they think for summary judgment purposes it is a case that's got a real prospect of success. Normally they will find that there is a dispute on grounds that are substantial. Summarise the relevant points in the handout. I'll quickly go through them. This again is taken directly from the guidance on summary judgment. The dispute has to be real as opposed to frivolous. Simply an honest belief that a payment is not due on its own won't be sufficient to constitute a dispute on substantial grounds. The court has to look at whether or not on an objective basis it is satisfied there is a genuine dispute as the liability to pay a debt. A counterclaim and or a set-off rather than a direct defence is just as good in terms of whether or not there is a dispute on substantial grounds. Importantly, once the case of the Court of Appeal in Abbey National and JSF Finance says is that once the court is satisfied that there are substantial grounds upon which the debt is disputed, the court shouldn't then go any further and express any views as to the actual underlying merits of the case. They've been very clear to point out that that's a matter for formal litigation, and it should be resolved outside the scope of the insolvency proceedings. Again, I've set out in the handout some practical tips. First one seems obvious. Seek advice as to potential defences, and be aware that obviously, just like in the summary judgment jurisdiction, the threshold for what is dispute on a substantial ground is fairly low. The best way to flush it out normally is to write, prior to issuing your stat demand, some sort of letter before action or formal demand inviting the debtor to set out whether or not they think there are grounds for disputing the debt. What that will often do is give you some potential costs protection if, when you get to issuing your stat demand, the debtor then comes up with some kind of defence. If you've invited them and provided them with an opportunity to set out a defence, they haven't taken it and haven't responded, and then they raise something at the last minute. I've had a couple of cases where judges have said, rather than the usual order that the creditor pays for the costs of the dismissed stat demand, there was either no order as to costs or we got our costs because the debtor had failed to set out when they had the opportunity to do so the fact that they were disputing the debt and the grounds they were doing it on. If you do have, if you think there might be a dispute, one of the key issues, and it's talked about in the cases that I've set out prior in the handout, is contemporaneous documentation. If a debtor says, I don't accept this, but that view is contradicted by contemporaneous documents, or not supported by it and in and of itself appears to be inherently implausible, there is appellate court guidance that says the court should take a dim view as to that and dismiss it. The last of the three heads is offering to compound or secure the debt. As I said at the start, this is something that normally comes post-stat demand rather than pre-stat demand, but it is an area that people often get into trouble with. In personal insolvency, a bankruptcy petition may be dismissed and costs may be awarded against you in circumstances where you as the creditor have refused to accept a reasonable offer to either compound or secure the debt that you have demanded. In the handout, there is a relatively recent case, Hughes and Howell, which is a 2021 Court of Appeal case, in which the Court of Appeal has considered and set out what are the relevant issues for a creditor to take into account when considering an offer to compound or secure a debt. What the court has to look at broadly is whether the decision to refuse an offer is so unreasonable that no reasonable hypothetical creditor in the position of that creditor would have said no to the offer. It's an objective test rather than a subjective test, although in fact, far be it from me to gainsay the Court of Appeal, but the way they then go to set it out is actually it's a bit more of a hybrid subjective objective test. The court's got to look at the position of the parties at the date of the hearing. The court is not limited to considering matters that were actually taken into account by the creditor when the offer was refused. They can look at the wider context of that and look at, on an objective basis, what they think would have influenced a reasonable creditor's thinking. The debtor has to be full, frank and open when they're making their offer and providing their information in relation to the offer. If there is any hint that the debtor has either been attempting to mislead or not state their position correctly, it will normally be the case that it was reasonable for the creditor to refuse the offer. An interesting point is what I've set out at 6 there, which is a reasonable hypothetical creditor is obliged to consider an offer on its merits. A rigid institutional policy of rejecting offers could be a relevant consideration. This comes from, this principle was summarised from a thread of cases involving HMRC, in which HMRC at the time, when they were dealing with offers from debtors, had a blanket policy that they did not consider offers to settle once they'd got to the stage of making formal demands. What the Court of Appeal summarised in that point is that whilst the institutional policy might be relevant, what they would expect in all circumstances is that a reasonable hypothetical creditor would at least consider an offer on its merits. That's one where I've had a couple of times before when you're acting for bigger clients, bigger corporate clients who may take a policy in relation to that you've got to be careful in advising them in relation to. Quite often, local authorities, large FTSE 500 or 250 companies will take a view as it's too much bother for us to look at these offers on its merit. We've got a blanket view that once we're at this stage, we're not going to consider discussing offers to settle. Normally, you can come unstuck doing that. The Court of Appeal have made it clear that they expect you in most cases to consider an offer on its merits, no matter how frustrated you've been with the process up to that point. There's no obligation on a creditor to take a risk or show any more patience or generosity towards a particular debtor than anybody else. And seems obvious, but the costs and resources implications for a creditor are a highly material consideration. Again, this can be very relevant when you're dealing with big clients versus small clients. If you're dealing with a big client with a lot of resources, it may be that it's more reasonable for them to consider an offer than a small or medium-sized enterprise for whom resources are tight and they really need the money in. In terms of a couple of practical tips that I've set out, what is very useful, and I've had a case where we won on the point of it was reasonable for us to refuse an offer, was where we were able to demonstrate that this particular debtor had a history of making promises for payment and then failing to deliver on those promises. In that particular case, the judge said that was influential in her decision making, because this was somebody who, and I suspect you've had experience of this yourself, you've got a debtor who every time they're presented with something says, oh yes, I'll have a payment plan for you and I'm going to pay you back within 6 weeks, 12 weeks, 26 weeks. And as soon as the first or second instalment comes up, they've defaulted and they're looking to renegotiate. That's highly significant when you're dealing with, or when you're justifying a decision to refuse an offer to secure or compound. And secondly, and tying in with the earlier points in relation to service, if you are going to refuse an offer, produce a witness statement that sets out, that effectively shows you working. It's much easier to justify those decisions if you have in advance or contemporaneously set out, this is the decision, this is why we've done it, these are what factors we've taken into account, and this was our end conclusion.